Hello there and welcome to your online tutorial 14. We're now starting part 3 of your course, which is attending court on criminal matters. We've previously looked at attending court in relating to civil cases or attending before a district judge in chambers. Now we are going to be looking at the subtle differences between going to court on civil cases as compared with criminal cases. Your study notes make a suggestion about what items to carry with you at all times, and these we would recommend to keep with you constantly in your briefcase. The notes about pens are actually quite important because I personally have been in a situation where I've been in court during a criminal trial, and at a crucial point while I was taking notes, my pen ran out. And it's no fun, believe me, when you have to explain to counsel and then your solicitor that you only had one pen and that's why there's a whole section of notes missing. Well, I'm sure that's why I was not taken on by that particular solicitor, as a matter of fact. But I did learn from my mistake, and that's why I'm imparting this knowledge to you. Always make sure you have a handful of pens with you at all times. As for counsel's notebook, you can do a search online. A lot of online stationers offer these, so no problem at all. They offer them by mail order, Amazon, etc., etc. Now, as previously discussed, we may be asked to pick up the file from the solicitor's office, and as previously mentioned, you should read up on the case file to familiarise yourself with the case so far. However, in addition to doing that, and for your own satisfaction, and remember we're dealing with criminal cases here, you want to find out a little bit about the client you're going to meet. You do this by checking in the file to see if there's any other information about the client, such as a list of previous convictions, if any, or whether there's any social or welfare report on them. Because you may be asked to meet with your client, and sometimes the client may already be in the cells beneath the court, and going down there is quite daunting. On page 5 of your study notes, you're asked to think about a scenario. Please pause this tutorial and read it if you haven't already. Come back when you've made up your mind. There's no right or wrong with the answer to this. It merely tests how you think. So, if you believe that the right answer is number 1, is that because you think it's not allowed, or because it's not professional, in your opinion, to give the client food? Well, it is perfectly acceptable to give your own client something. Remember, you have already been searched. The only rule about that is not to give the client a packet to take away with them. As to whether it's professional or not, that is your call. You're the only one that can make up your mind at the time if you want to keep it strictly professional and distant, or be a little bit more friendly and break the ice. Let's face it, you've already ascertained whether your client has got previous convictions. If you found nothing in the file, then you can make an assumption that he is of clean character. And maybe this is a first offence. Of course, you may also take an instant dislike to this person, as one does quite often when we meet people generally. And that is something else. Having said that, we need to always remember that it is your client, and client care takes priority, whatever that means to you. If you think that offering a Malteser, for example, will break the ice and put the client at ease, then you may think it's worth doing. If not, then don't. Of course, you may just want to keep all the Maltesers to yourself, and that's another matter altogether. So we've come to the end of OT 14. See you at the next one.